Good morning, everyone, and welcome to this breakfast briefing with me, Kaz Carrington of KLC Employment Law. Over the next 30 minutes, I'm going to be discussing how to avoid making mistakes when you're undertaking disciplinary hearings or managing them in general, as you would be possibly as the HR representative in your organisation. As we go along, please feel free to ask questions electronically, of course. My colleague Melanie Whittle is going to be supporting me today. Thanks, Mel. And she'll be answering your questions as you go along. But of course, alternatively, if you want to contact me after the webinar with a question, then you can do so via the KLC website. We also have a very quick poll at the end of the webinar for you to fill out. So it'd be really great if you could spare a few minutes to do that for me. And just a quick shout out to Kirsty Batten of GoHo, who's providing the technical support this morning. And do I need it? Yes, I do. So thank you very much, Kirsty. Okay, so this is what we'll be looking at. And these are the topics, really the headings that I should be covering in the next 30 minutes. So first off, let's talk about the letter that goes to the individual when we want them to attend a disciplinary hearing. Now, a little while ago, a client of ours rang us up and she said, Cass, I've just had a bit of a weird thing happen. I invited somebody to attend a disciplinary hearing and they've declined. And after we sort of stopped laughing about that, she didn't need to be reminded that, of course, it's not an invitation like it would be to a wedding, which you could politely decline. It is a requirement to attend. So we're very clear about it. You're required to attend. It is compulsory. It's not something they can opt out of. Other things in the letter itself that can put us on the back foot. We should always advise people of the worst possible sanction that they might face at the hearing. So, for example, if it's a gross misconduct offence, what we would say is you should be aware that the disciplinary hearing might result in you being summarily dismissed without notice or pay in lieu of notice. But of course, we don't want to put the worst possible case scenario in all situations. So if somebody is allegedly committing a minor act of misconduct, for example, we wouldn't want to say, you should be aware the outcome could result in your dismissal, because that would clearly be very scary for the individual and would actually be a breach of trust and confidence. How do we know this? Well, it's been run successfully at tribunal where somebody was told that the outcome might result in their dismissal when they indeed had committed only a minor misdemeanor, and they resigned and brought a successful claim of constructive unfair dismissal. So very careful, making sure that we do tell people what they might face, but we do that on the basis of the worst situation that they could face for that possible allegation. And that's all to do with natural justice. We often read, don't we, about must observe the rules of natural justice. And what that really means is just the rules that everybody would expect to be judged by if they were indeed accused of something. So, I want to know what it is I'm accused of, who my accusers are, if possible, please. And then what's the possible outcome? What's the sanction I might face? It's just fair. Other issues with the letter could be that we're a bit coy sometimes about saying what we mean in terms of allegations. The most famous example I can think of this was actually actioned at tribunal, and it was where there was an accusation. It was quite clear what was meant. Somebody was accused of stealing some money. The allegation should have been that she had stole some money from the strongbox, let's say. When it appeared in the letter, however, it was just phrased in terms of monies having gone missing. Now, how do they go missing? Do they disappear into thin air? Did somebody else steal them? It wasn't clear. And because it wasn't clear, she didn't know what she was facing, and therefore it was held to be an unfair dismissal. Because actually at the hearing, it was quite clear and evidenced by the notes of the hearing exactly what they were accusing her of. And indeed it was theft and not that she'd just lost the monies, etc. So we're very clear, we're not coy about those allegations. we are crystal clear. Sometimes we see that there are more than one. There's more than one allegation, so it might have 2 or 3 gross misconduct allegations. And sometimes the letter is written in a way that might suggest that all 3 have to be found for it to be found in terms of gross misconduct and therefore possibly summary dismissal. And what we want to see is in each case that those allegations stand on their own. So if any of the allegations are found, that might result in your summary dismissal. Again, something just to note that it's an easy mistake to make, but can really come back and bite us if we're not careful. Once we have sent our letter out and we want people to attend, sometimes people can't attend, sometimes people go sick, and that's not often a big issue for us, because if it's a minor case of misconduct or not so serious, we can delay a hearing, we can wait for the person to get well and come back into work. Sometimes, however, it's gross misconduct, and it might be that the individual is feeling very unwell because they're under stress because of the allegation. Of course they would be. It's a natural reaction, isn't it? When you are accused of doing something, whether you're innocent or guilty, it's still going to put you under pressure. So what do we do in these situations? Can we stall? Can we wait? A bit like with the investigation issues that we talked about in the briefing last month, we wait and see for a little while. We try and investigate why the person isn't able to attend. And if it's really a case that that person won't be able to attend for a jolly long time because they are all far too poorly to attend, then we have to make some calculations. And those calculations are based on the fact that case law tells us that really it's the most unfair thing we can do to hear something in somebody's absence. But that is versus the fact that the longer we don't hear a matter, the more likely it is to be unfair, because memories fade, and the passage of time itself could actually render the dismissal unfair. And so what we do generally is, once we ascertain that somebody's going to be out and not available for a very long time, we ask for alternatives to try and evidence fairness. So could the person be represented by somebody else at the hearing? Would they like to offer us written submissions? We bend over backwards to evidence fairness, but sometimes we just have to crack on because it's the lesser of the 2 evils that we're presented with. Now, what is sometimes useful is if you have that written in your policy and procedure, just something like, there may be some circumstances where we have to hear something in your absence when you are ill, etc., etc. It does 2 things really. Firstly, it serves as a mechanism for, this is what we do, so it's not extraordinary. We're not picking on you, particular individual. And secondly, it serves as a mechanism, I guess, as a warning for people who might just be cynically going off sick to avoid the disciplinary action. So we're saying, just be aware that in these circumstances, we may just go ahead and hear it in any case. So there's not much point in you trying to put a fast one in that way. Accompaniment at hearings is a statutory right when the hearing is going to result in some sort of formal sanction, as you know. And under Section 10 of the Employment Relations Act, there is the right to defer a disciplinary hearing where the employee can't get the accompanying person of their choice because for whatever reason it isn't convenient, and the deferral is up to 5 working days. So that is a statutory right. It's nothing that we're bestowing by our good nature. They are able to do that if they can't get that accompanying person. Now, what we do know is that if you are so rigid with that 5 days and say, okay, 5, we're held up for 5 days, but I'm sorry, we just won't hold up for 6 or 7 or even a month. If we do that, then that might not actually be good enough to satisfy the requirements of Section 98(4) Employment Rights Act, which we come back to time and time again when we're looking at issues of disciplinary matters and dismissal. Because what Section 98(4) tells us to do is, in all the circumstances of the case, we have to act reasonably. Now, very famous case, and if you want to look it up, please do. It's a Talent Engineering versus Smith. It was an EAT case. And this is where the individual, they'd already deferred the meeting for reasons because people were absent. It was nobody's fault. And then he wanted to defer the hearing further because his rep couldn't join on that particular day. And they said, no, we've gone far enough, that's it, we're going to go ahead. He didn't turn up because he couldn't have his rep of choice. They went ahead and dismissed him for gross misconduct. The man had 20 years service and it was held to be unfair. Now they were, what did we do wrong? We deferred for the requisite period of time. How much fairer could we have been? And of course the answer is from the EAT, well, you should have observed what's required in section 98.4 of ERA, reasonable circumstances, you could have deferred a bit longer. It was clear to the EAT that the individual was really sort of not doing this in bad faith. He really couldn't get the rep of his choice. So do remember, just observing those matters won't always get us off the hook. We're at the hearing, and hopefully you have provided the individual with all the information, the evidence, photographic or otherwise, that you intend to rely on, to discuss with them. What we don't want to see clearly is, imagine we're at the hearing and I ask the employee, so you're quite sure you weren't in the cash office at 3 o'clock on Monday the 12th? No, absolutely sure. Are you quite sure of that? I'm absolutely quite sure. And then we present, well, what about this then? This is the photographic evidence. We've caught you out. Clearly, we don't want to do that, because even though you might have proof perfect that that person was there, you must provide that so that they have the opportunity to be able to tell you why that was possible. The other important point to remember, and if you joined last month when we talked about investigations, we talked about sometimes giving witnesses anonymity. Now, where we do that, and we'll only do that for good reasons, but where we do that, we need to observe the rules of natural justice, as I mentioned earlier on. And that means that really, as far as possible, anybody accused of anything should know who their accusers are. So where we have agreed anonymity, what we would want is for the hearing manager to be able to talk to that witness themselves. And if that were not possible, because anonymity was granted in a way that we don't even know who the person is, let's just say, then at least the hearing manager will talk directly to the investigator. So there is some direct contact. That is really a requirement where we do allow anonymity of a witness who might be giving really important evidence. We call these meetings hearings for a reason. Often we'll see invited to a meeting, well, not invited, and it's not a meeting, you're required to attend a hearing. We call it a hearing because that's exactly what it is. We want to hear what the individual has to say. And so we do want to make sure that we offer that opportunity. You've seen, our witness statements. What would you like to tell us further? What do you want to tell us about what happened on that day? Please, now's your opportunity. We don't want it to be done in 5 minutes. That will not evidence fairness. We need to have in the notes that we have given every opportunity for the individual to tell their, if you like, version of events. Makes it sound like kind of what they've just made up, but their side of the story, if you like. Now, clearly you'll be observing the ACAS Code of Practice on disciplinary and grievance procedures, because clearly your policy and procedure with regard to disciplinaries will have incorporated that already. Important to note that the ACAS Code does not require cross-examination of witnesses. Some procedures have it written in that the individual can cross-examine, but what is required is that the employee may call witnesses. So they might call 3 people to say something that they want them to say. I think some of the misunderstanding, if there is any, with this issue of cross-examination is many years ago, about, I don't know, over 10 years ago, probably longer, the ACAS Code of Practice was revised, and in its draft form, its new form, it actually mentioned the right to cross-examination. That was then actually removed before it became the proper document, the actual code. And I think somehow that stuck in people's minds. What, of course, we do want to make sure we do is if somebody says that witness is not telling the truth, I want to challenge that, then we say, okay, exactly what do you want to challenge? We will go away and we will pose those questions to that witness to make sure that you're again observing fairness. But actually cross-examination of your witnesses is not required by the code. But we do want to make sure we are being fair. Have you got anything further to add at coming to the end of the meeting? And we always adjourn, and not just for 5 minutes, please. Again, famous case Khan versus Stripe Star. It was flawed, the process and hearing, for lots of reasons. But one was because basically the hearing lasted 5 or 6 minutes. Now, you really can't go through everything sensibly in that time. Actually, in that case, and something to note as well, it was horribly flawed for lots of reasons, the investigation and the hearing itself. But what they did on appeal, because the individual, Mr. Khan, appealed, they ran the hearing as a complete, if you like, the appeal as a complete rehearing of the disciplinary matter. And as you know, in that way, you can put right all and every procedural error. They did that after Mr. Khan appealed, and then they dismissed him, and obviously this time they did it fairly. So again, that's something to note, and something we might talk about in other breakfast briefings going forward. Another thing to make sure of is that you're not being recorded during your private deliberations. Now, you know, we know that if you're recorded during the course of the hearing, that will probably be admissible as evidence. So you're always very clear and circumspect about what you're saying. But in your private deliberations, you're probably a bit more relaxed about the way you're talking to your colleagues. So always make sure you leave the room so that you're leaving the room. They can't leave any recording devices there with you. Because what we do know is that while tribunals abhor people recording others covertly, they have very wide ability to be able to pull things into evidence. So if a recording, for example, demonstrates that you are being unfair, or indeed, as has happened in the past, it's quite clear from the recording, the disciplining manager hasn't made the decision to dismiss, it's been maybe the CEO or somebody else in the organisation, that could be pulled into evidence. So where you are going out with your brief in that private deliberation, that could be pulled into evidence. So be careful that that can't happen to you. Always you be the ones to leave during the adjournment. Decisions have to be made, as I mentioned, by the disciplining manager, the hearing manager, whoever is nominated to manage that meeting, unless you want the decision to be an unfair decision, because you are setting yourself up, if you're the hearing manager, to be the person who is making that decision. That's what the employee thinks. So that's what has to happen. What you don't want is for HR to make the decision or the CEO to make the decision. It's got to be the manager of the hearing. Now, how would anybody know, Cass, that I haven't made the decision? Well, supposing it goes to a tribunal and your hearing manager is giving evidence and they are asked, why did you make the decision to dismiss Mr. Smith? And your witness, your hearing manager says, well, I didn't, HR did. It's really sort of an own goal and game over. So they make the decision to dismiss. It is their responsibility. And by the way, well, they could just tell a bit of a fib, but of course they couldn't. That would be perjury, so they can't do that. They are looking to make the decision based on rational, objective and fair reasons. So you know what the test is. Have they formed a genuine belief on reasonable grounds after this adequate investigation? And that's what you can do as your HR support for your hearing manager. If they're floundering a bit, if they're saying, well, I'm not quite sure what to do here, they don't need proof perfect. In other words, they don't have to prove that somebody did it. I don't need to have the photographs that show that somebody did it. I just have to have formed that genuine belief on reasonable grounds. So really we can support the hearing manager by asking him, look, have you formed that belief and how have you formed it? And what did you think about the investigation? We can guide, we can support. And then I would always really end this by asking them to ask themselves, do you think any reasonable employer would dismiss? Because we know what the test is, don't we? If no reasonable employer would dismiss, then it would be unfair. So we've always got that in the back of our minds. Would a reasonable employer have dismissed in this situation? Now, once we get into, obviously, the decision about culpability, then we might get into mitigating circumstances if there are any. And it was going to be absolutely unfair if you don't consider if there are any mitigating circumstances. So we formed a genuine belief that this thing has been done, this act of misconduct has been committed. That would be the normal sanction for our organisation, and that's with the help from HR. Thank you very much for showing consistency and how things work, and etc., etc. Now, what are the mitigating circumstances? So we consider all things: the person's length of service. Have they got a clean disciplinary record? Have they been, an exemplary employee, or have they sort of, not been? Have they got sort of current misdemeanors, etc.? So if we're considering gross misconduct, for example, has the person already got a live warning? Because we might have saved them if they had a clean record, but actually this person doesn't look like they're kind of worth saving. So we're looking for those sorts of things, and we must evidence that we have looked at that, because remember, going back to that section 98(4) of ERA, in all the circumstances, did the employer act reasonably when making that decision to dismiss? Did they consider the length of service and the wonderful loyalty shown by this employee in the past? What we know we can do, again, because case law is stacking up to show us, that when we have two employees who commit identical offences, both gross misconduct potentially, yes, we found that they actually did commit them, we can treat them differently in terms of sanction. One might be worth saving. Well, for you, employee A, we're going to give you a final written warning. For you, employee B, same offence, but your circumstances are different, we're going to dismiss you. We know that is fair because of the way we have to look at mitigation. Where things really are obviously wrong, it tends to be because the disciplining manager, the hearing manager, hasn't been able to evidence that they form this genuine belief. It looks like the decision is irrational. It looks like it's based upon something they were told to do. So that's what we come down to when we're looking at that genuine belief. Have we formed it on reasonable grounds? That's what really gives that grounding in, yes, that's our evidence that we formed that belief, or the manager formed that belief. The other thing, of course, is, well, you've committed this particular misdemeanor, and this is what we're going to do, and it's kind of out of kilter. The sanction, the punishment, the penalty is out of kilter with the offence. So we have to guard against that. Now, in the outcome letter, because once we've had our disciplinary hearing, we will write and confirm. Now, generally speaking, what happens is we will adjourn, we will have then discussed our outcomes, we then present it back to the employee, and we say, we will confirm this in writing, and obviously in that we will obviously give you the right to appeal, etc., etc. Some things that we see in outcome letters to avoid, sometimes we see this, you have been given a first written warning for this offence. If you commit a similar act of misconduct, then you might face further disciplinary action. Actually, no, it doesn't have to be a similar act of misconduct. Any other act of misconduct, if you commit any act of misconduct in the period of your first written warning, then you may face disciplinary action. So careful on that. The other thing to be aware of that is, and I know this sometimes happens in organisations when it's possibly a dismissal, you have your adjournment and then you say to the individual, we will write to you with the outcome. And you do that and you decide to dismiss. Just be aware that the dismissal date, the effective date of termination, isn't the date you say in the letter. It isn't the date that you made the decision. It's the date that the employee has the opportunity to read that letter. So this is where we're not just confirming the outcome of the hearing, we are giving them the outcome by letter, by email. And again, case law, time and time again, has said the individual has only been dismissed when they've had a reasonable chance to read that letter. So for example, case I'm thinking about, they dismissed her by letter. She was called away on important family business and didn't really read the letter until 2 or 3 days later. That was the effective date of termination, not when they had said it was, the employer. And of course it mattered because it meant that her claim from their dismissal was actually in time rather than out of time. So do be aware of that. The other thing to avoid, really, you must, if you possibly can, and we do see this a lot, is we consider all these things and I had no option other than to dismiss you. No. There are always other options. And what this tends to evidence is that you haven't really considered mitigation. So just avoid those words. It looks like intransigence. It looks like you haven't been open-minded to mitigating circumstances, etc. So my top 10 tips for you, please. Follow the ACAS Code of Practice always. That hopefully is enshrined already in your own procedures, but follow your own procedures. You don't want to have a procedurally unfair dismissal. So if it says one level of manager will hear this matter, you stick to that, otherwise it could be procedurally unfair. Of course, if you've mucked up in procedure and the person appeals, remember that's a double-edged sword for the employee because it gives you, the employer, the opportunity to rerun that a hearing through the appeal and put right those procedural flaws. Clear allegations, say what you mean, don't be coy. Share all the evidence, no surprises, no, what's this at a hearing. Advise them of the worst case scenario for the particular misconduct they've allegedly committed, not for the worst possible case scenario. That would be potentially constructive unfair dismissal. If you have anonymous witnesses, you've allowed anonymity, remember those natural justice rules that the hearing manager should try and see them, to eyeball them if they can. If that's impossible, at least the investigating manager should have that direct contact with the hearing manager to talk about that individual witness. Let our managers be able to evidence that they form this genuine belief. That's going to give you your cornerstone for evidencing fairness and obviously evidencing that the manager made the decision. So we really want the manager to make the decision. We can guide, we can prompt, we can ask them to ask themselves certain questions, but we must make sure that it is the hearing manager that makes that decision. And only consider mitigation once you've formed that genuine belief. So it gets in the way otherwise, it kind of clouds things. We think this person did it, okay, we've formed our genuine belief, now let's consider, because this would normally be the sanction dismissal, now let's consider the mitigating circumstances. That's the way it should form up. Always ask yourself, is there a reason why we shouldn't dismiss this person? And always ask, would any reasonable employer dismiss? In other words, that band of reasonable responses test. If no reasonable employer would dismiss, it will be unfair. However, if a reasonable employer would dismiss, then the tribunal should find the dismissal to be fair. Okay, we've kind of come to the end of this morning. I'm in time, which is good because I wasn't last breakfast briefing. I went quite a bit over. So just a couple of things before you go, if I may. Firstly, please could I politely ask you to fill in the poll if you've got 2 minutes spare. That would be absolutely wonderful. Secondly, you may not know, but I'm taking the Law on Tour back on the road in July. We're going to be offering it at venues, via virtual classroom and via webinar. If you're not familiar with the Law on Tour, it's a brilliant, comprehensive one-day employment law update where we have lots of lively sessions, have fantastic documentation, case studies. It's a really good learning day. And of course, it's a chance to catch up with all your kind of like-minded HR colleagues. So if you haven't heard of it before, or if you haven't yet booked, just hop onto the KLC Employment Law website and just click on Law on Tour, and there's a piece there all about it. So thank you so much for joining me this morning. I hope you've enjoyed it. And if you have really enjoyed it, then don't forget to sign up for our next briefing next month. So goodbye for now, everyone, and I hope you have a very happy day. Bye now.